Hi, welcome to another edition of IP Somm. I'm Heather Boyd from Pillar IP, and today's guest is my good friend Dan Gurfinkel from the Windy City, Chicago in Illinois, USA. And he's one of my favorite patent agents down there. So Dan, would you like to tell us a little bit about yourself, please?
Hi, Heather. Yeah, I'm sure I'd love to tell you about me. That's all I do is talk about me. So I've been a patent attorney for, I think, 32 years, something like that.
Oh,
Since 1990 or just before 1990.
Kevin.
I've worked for small, medium, and very large firms. I'm currently with Dennemeyer and Associates in the Chicago office, which I founded with them in 10 years ago. In 2010. So I do a mix of patent and trademark work, which has basically been throughout my career. When I first started, obviously as a young associate, I was involved in some litigation, but since then it's mostly been prosecution.
And we've been working together for closer to 10 or 12 years now, I guess.
I think so.
That we've been doing the work together, and yeah, I really enjoy working with you. So today we're going to talk about patents, just like patent basics kind of thing.
Sure.
So if you can, but before we do that, are you drinking something?
I am. You asked me to pick something that I enjoy, and I went with a Glenlivet 12-year-old Scotch, single malt.
Show us the bottle.
Oh. Nice crystal glass. So
you gotta pull it up closer so that we can actually see the color in there. Nice amber colors and everything. I'm drinking a Gentleman Jack. I'm gonna show you the bottle. So mine's a Kentucky bourbon. Mm-hmm. And I picked this one because you have always been a gentleman and a scholar to me. I think we met because of
cigars and whiskey.
I wasn't there for the cigars. I was only there for the whiskey. I'm drinking this out of a Norland glass. You know, that's the subject of 4, I guess they're design patents. Is that what they're called, design patents?
Yes, in the United States they're called design patents. I think in Europe they're just called designs, and they're part of the trademark system instead of the patent system.
Right, and in Canada they're called industrial designs, okay. And we can file them as a trademark agent as well. So some of the nuances you want a patent agent on there for, but you're going to tell us about not design patents. Well, you could talk about that as well, but the basics of a patent. Now, primarily you're talking about U.S. patents, but I think they're kind of the same all over the world, right? A patent.
They're very similar all over the world, and particularly between Canada and the United States, they're very similar.
Okay, so why don't you start by telling us what is a patent?
A patent is a monopoly of a certain amount of years on an invention. And it can be chemical, electronic, mechanical, and software. There's been some litigation on software recently, and some of it has been cut down a bit, but those are the main groups of patents in the United States and around the world. And then you have products and methods between them. So you can have what the thing is made up of, or how to use the thing, as opposed to products and methods.
Maybe because you're like even talking over my head almost already. And this is where the general public, everybody, their eyes start to glaze over as patent agents start talking. So let's take it back down to even further than that, because I think you're referring to what the patent registration process is and what's patentable versus, just the definition of a patent being an invention, right?
Well, an invention is an invention. A patent is a monopoly on that invention. It gives the owner the right to use, make, and keep others from using and selling the invention.
And the rights extend from filing of the application, or from public disclosure, or from registration? Which one?
Well, the rights can be drawn all the way back to when it is published, which is usually 18 months after an application is filed. But it isn't really enforceable until the patent grants. I think that's what they call it in Canada and the United States. It's an issue.
Yeah, we call it issue as well. What can be patented?
Invention that is new, not obvious, and useful.
Okay,
Has to be some utility to it.
right. So in our conversation leading up to doing the taping of this, I kept saying new, unique,
And
and
novel.
and novel. I used all three, which are all synonymous words. Basically, you have to be the first one to the drawing board, so to speak. On your
Well, interestingly, the United States used to be first to invent. And when they did the American Invents Act about 10 years ago now, I think, maybe more, they changed it to the first inventor to file.
oh, so it follows the same as international practice.
Right, right.
Okay, okay, okay.
Which eliminated the pretty much the contest that used to occur when two inventors had the same invention. And for the life of me, I had that word in my mind, and now I can't think of it. But there was for example, the telephone. Alexander Bell went through one of these trials to determine who invented the phone first, and Bell was actually shown to be the first inventor. So yeah, that the first inventor to file pretty much got rid of that kind of proceeding.
It has to be new, non-obvious. What's that mean?
Well, so if you had a glass that was square and had three sides, and you came up with the invention of putting the fourth side on it so that liquids could be kept in there, that's a pretty obvious thing to do.
Oh, that's a really good analogy. Yeah.
That's just a terrible analogy, but
It works for me.
All right. Yeah, you can't invent something that is just, the next step.
So let's talk a little bit about utility. What's that mean? Like, do you have to, I've had this question asked to me 100 times, do they have to actually have a working model to patent something?
You do not, but it must be seen to be something that works. It can't be, the steps include this, a Martian's eyeball, and then this, because, that part doesn't exist. So it has to be things that are, if you read it and understand the patent, you would be able to recreate it.
Okay. So a patent in and of itself teaches other people how
Yes.
to use that technology or that product or that
how to create
invention.
And that's the genius of the patent system, because what it does is if there were no patent system, people would keep things secret, and there would be a lot of trade secrets, and there would be people reverse engineering, and then you would think, well, companies aren't going to invest money in an invention if someone else can just take it and build their own. So the patent system gives to the inventor, for a period of up to 20 years, the right to make, use, and sell the invention, and keep others from doing that. So it's funny because it's not really an exclusive right, it's an inclusive right. You can make, use, and sell it. No one else can. And so by making this thing available to everybody through the publication of the patent or the invention, the next generation of people can look at this and build on that, so that we continue to move forward in progress in invention.
Right. But what's the benefit of getting a patent registration?
A patent gives you an exclusive right to make, use, and sell the device for the time period of the patent, which is
and that runs from
20 years from the day it was filed.
From the day it was filed, not from the date of registration, right?
No.
Okay.
No. That changed with the American Invents Act of the United States. Many countries before the United States had the 20 years before filing. The thing that caused the U.S. to change was that people were filing patent applications and then filing continuation applications, which you could do as long as an application was pending, and keep the whole patent application running forever.
Right. So how do you protect a patent? What do you do to get it right?
Well, what we do is we try to think of any way someone might get around the patent, and then write it out so that it is both broadly disclosed, and then is narrowed down to be more.
Sure, that seems like a contradictory statement there.
Well, no, but I mean, you want when you have a list of claims. The claims are the fence that goes around the thing you're inventing.
Okay.
Right. If you're using very broad terminology, let's say I'm inventing the glass. All right, and the glass is next to the mouse. All right, so I have to have.
Mine's next to the chocolate. It goes
Okay.
really well with whiskey.
So if my fence covers both the mouse and the cup and the glass, it may be too broad.
Okay.
So I have to narrow the fence so it only goes around the glass. So you do the broad claims, and then you do the more narrow ones, and what that does is it gives you your best chance of getting something at the patent office. So I file something that is very broad, and as I work my way down, it gets very narrow, and the examiner will find art, these previously published applications, all the patents that have issued in the past, newspaper stories, journals, anything that can have a date on it that can be verified from a certain date. And they'll say, yours isn't new because this existed.
Okay.
So I say, okay, the thing that existed was like this. So I'm going to narrow it a bit. Instead of saying fastener, I now put screw.
Okay.
So because a fastener can be a nail, can be Velcro, can be glue, can be anything. And now I'm narrowing it to a specific type of fastener.
Okay.
That might get me past that piece of art that the examiner has found.
Okay.
So I want to have in my patent application all the different things. I want to have fasteners, I want to have screws, I want to have Velcro, tape, glue, tacks, rivets, all of that, listed in the patent application. So at some point I can just pick one if I need to.
What's the process that you would recommend for people who think that they have a new, non-obvious, and usable invention?
There's different ways of doing it. For a smaller client, the idea, the choice of what's called a provisional patent application might be the first choice. And that's just very simple. It can be very simple because no one has determined what legally is needed. But to cover all grounds, you should have a specification that lists what the problem is and a solution.
What about organizations that offer up their, we're in a digital world now. There's a lot of software platforms and software services, those kind of things. What if you offer up your platform or software as a service in beta testing?
Well, you would have to have everyone who's in the beta testing agree that it's secret and they can't disclose it with a non-disclosure agreement.
Okay. Take note.
But even then, software has had a lot of problems of late in the United States Patent and Trademark Office. It's difficult to get a patent on an invention dealing with computers.
And is that because the computer language that's used? It's a different function, but it's the same.
Well, when you do a patent application on a software, something that uses software, something that is software, you're not getting a patent on the language because that would be too limiting. What you're doing is getting a patent on the steps that the software takes.
Okay.
And if the courts or the patent office, now that they've got the opinions of the court, look at that and see the software through the steps it's taking as something that someone could do in their mind or by hand, it's not patentable. That's just an algorithm that's just something that anyone could do. And the use of the computer, all it does is make it more accurate and faster, which is what a computer does. So there's no real invention there.
Let's go back to that and talk about, when you're advising your clients that don't have deep pockets, let's say, how do you How do you
Actually, go
counsel
ahead.
them in what they should do for whatever it is that
All right.
they're
Well, the
trying to
provisional patent application is a document that can be very brief. It can be very detailed. As I said, there's no one has said what it should consist of, but it's a disclosure of your invention
Okay.
that is filed in the U.S. Patent and Trademark Office. For a small entity, the fee is $150. It can be done by the person. You know, it's a couple of paragraphs and some drawings or images. So the provisional patent application is something that can be very simple and very inexpensive to file at the USPTO. And what it does is it gives you 1 year from the date you file it, where you can claim that early date on your regular patent application. So you have provisional and then regular, so or non-provisional, which just seems like a lot of words to say regular. But so you have these two applications, and the regular application needs to be filed no more than 1 year from the provisional in order to get that early filing date. It's a 1 year priority.
What's the difference between provisional and regular?
The provisional will never be examined. It just holds the place.
Okay.
It won't be looked at by the examiner unless you cite it in the application and say, for example, if you forgot to mention something in the regular application, you could say, oh, it was cited in the provisional, and then that might be brought forward and looked at. The only time someone would look at the provisional, I think, is during litigation to see if you blew it there, that you didn't have the right disclosure for the full application later, and so you shouldn't get the early date for everything.
Okay, so tell me how that's a benefit to people who don't have deep pockets to file one application and then file another more expensive application.
Well, the first application allows you to have an application date, which means that you can then disclose your application to anyone you want without jeopardizing your ability to file a patent application.
So ding, 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 that means you could potentially sell your invention to someone else with deeper pockets who could then patent it, right?
Or you can go get some investors who say, you know, that's a good idea. I'll give you some money to get a patent application written and to do some research and build the device. It allows you to do that without ruining your chances in other countries that have absolute novelty. It also allows you to continue to work and think about the application so that when you write the full application, you cover everything you want to cover.
Dan, let's talk about patentability. Because I always recommend to my clients when they've said, oh, I believe I have the next greatest thing, and I do a quick Google search and I find something that's kind of similar to it.
Yeah.
There, you say you don't recommend a patentability search, but
I don't always recommend it because whatever you find in a search has to be disclosed to the patent office, at least in the United States.
Okay. Well, information disclosure statements here in Canada, it's the same thing.
Yeah.
Yeah.
But that doesn't mean that they're not going to find it. But you know, when you have a client that is in the business of making things and they know what the cutting edge is, the patentability search is expensive. It takes time, not too much time, but it takes time. And then when you review it, there's not necessarily a correlation between doing one of these searches and being clear.
You mentioned earlier that Google Patents is that an actual website they can go to?
Yes, if you go to Google and type Google Patents,
and then
it'll look almost like Google, but then you put keywords in. You can put patent numbers in too if you know the patent numbers, but you put keywords in, wheelbarrow, tire, dirt, and it will find anything that has those words in it.
Okay. And then do a search for international, what would you search? International patents?
Well, the Google search will show you patents from all over the world. I mean, it's a phenomenal search.
Is that important to learn about whether there's a patent over in, let's say, Azerbaijan? I can't even say that word.
Azerbaijan.
Azerbaijan.
Yeah. Anything that is published can be used as prior art. So yes, an Azerbaijani patent, if it shows exactly what you're doing, is prior art to you and can keep you from getting a patent. Just to recap, when we're doing looking to protect an invention. I think the first step should be that the inventor who comes up with something, write it out. A couple of paragraphs, some drawings of how it's done, and then put it aside and take a look at it the next day to see if there's anything else that they can think of. Right, so then file the provisional patent application, which starts your earliest date possible for having that invention. At that point, you are free now for an entire year, maybe not the whole year, to look for something, to do searches, to look for investors, to actually hire someone to do a patentability search. Your investment has been very low to begin with, but you have, at this point, protected your invention. You've protected it that no one can have an earlier date than you if you were the first one to invent it, and you've protected it in that you can go to a country that has absolute novelty without fear that you're disclosing it to someone. Because when you do your Google search, you're sitting at the Ottawa Public Library, sitting at the computer doing your Google search, and someone looks at it, you've disclosed your invention. But it doesn't matter because you have your provisional application on file.
Can an individual or an organization file their own patent application?
Absolutely.
They can file direct?
Filing it pro se.
They're filing it pro se, is that what they call it? Yeah. What do you recommend that?
When you file pro se, and we've taken over applications from people who filed them themselves. If you've never done it before, there are a lot of pitfalls that you will fall into. But it takes some time, you know, from when you first start filing them to getting good at it, writing a patent application.
But I think it's a different language in and of itself when you're filling out forms and stuff like that for patents, for trademarks, for whatever. Why would you not? I mean, the amount of time that I can spend on filing an application or drafting an application just on the trademark side, which is completely aside from the amount of time, which is significantly more for drafting a patent application. And then the language on the forms themselves. I mean, even Canada is kind of antiquated. The US, it can trip you up. You could put things in there that you're not writing. Why would you want to risk having your entire application completely thrown out because you didn't understand what they were asking?
Right.
And perhaps you've disclaimed every distinctive element of your trademark or your patent you know, filing the application. Go to
Well, that's exactly right. I mean, I've looked at write-ups that people have sent, and the thing I look most for is it'll be obvious to do this thing, and you never want to tell anyone that it's obvious to do this because that
don't make any admissions in there.
Yeah, you're making admission that it's not new and novel, which are synonyms, new and not obvious.
I think that's the basics. Really, if anybody has any other questions, we're going to put Dan's email address up here so that you can reach out to him in the US. If you have questions about patent processes and applications or whatnot in Canada, feel free to contact us at info@pillarip.com. Thank you for joining us on IP Somm. I hope you enjoyed what you see. If you did, please like, share, comment below, and subscribe to our YouTube channel. Remember, we're not providing legal advice in these videos. We're just talking IP and sipping something sweet. Cheers.
Cheers.